Hi, everyone. Judge Andrew Napolitano here for Judging Freedom. Today is Monday, December 5th, 2022, getting close to Christmas. It's about 2:45 in the afternoon. Just a few hours ago, the Supreme Court held an oral argument involving the Colorado anti-discrimination law. Again, we went through this 5 years ago. Remember the case of the baker, the Christian baker in Colorado who did not want to bake a cake for the wedding of a same-sex couple. That case made its way all the way to the Supreme Court, and the Supreme Court basically punted. Instead of ruling on the underlying issues, free speech and religion on one hand versus freedom from discrimination on the basis of sexual orientation on the other hand, the Supreme Court more or less punted and ruled for the baker, but just on the facts in that case. There was a lot of animosity shown by the civil rights officials in Colorado against the baker, and the Supreme Court ruled in his favor because he didn't get a fair hearing in the Colorado administrative courts. That was at least the Supreme Court's ruling 5 years ago. It's an entirely different Supreme Court today. Today, we have a same-sex couple. Again, this is gay rights, same-sex marriage versus freedom of speech. We have a same-sex couple that wants to compel a web designer to design a website for their upcoming wedding. I don't know why these people don't go somewhere else. If somebody didn't want my business, I wouldn't want to pay them. But okay, I get it. I understand. I understand why we're there, and that's what the Supreme Court exists for, to tell us what the law means. So you have the Colorado law against discrimination, which says if you are a public accommodation, if you are a landlord, if you are the seller or anybody involved in the selling of real estate, or if you own a business that invites the public to your business, public accommodation, you can't discriminate on the basis of LGBTQ status, as well as the other traditional prohibited bases for discriminating: age, race, gender, religion, ethnicity, etc. We also have the First Amendment, which says that Congress shall make no law abridging the freedom of speech. That also means Congress shall make no law compelling speech. The 14th Amendment applies the First Amendment to the states. So the states can't compel you to speak, make you say words that you disagree with. The states can't compel you to make an argument that violates your religious beliefs, just as Congress can't. So that's the clash between the Colorado state law prohibiting discrimination on the basis of LGBTQ status and the Constitution prohibiting all government from compelling speech, prohibiting speech, or compelling you to make any kind of a statement against your religious views. That's what's before the Supreme Court. I honestly think this case is going to go against Colorado and in favor of the web designer. I make that conclusion from reports of the oral argument this morning. This, of course, will open up a can of worms, because the Civil Rights Act of 1964, the Federal Civil Rights Act, also applies to LGBTQ status. The Civil Rights Act of 64 really opened up this can of worms when it did two things. It said to the states, you can't discriminate on the basis of race. That's correct. That's what the post-Civil War amendments were written to prohibit: discrimination on the basis of race by a state government or any government within the state, county, local, or regional. But the Civil Rights Act of 64 went one step farther and said no public accommodation may discriminate on the basis of race. I get it. That's been the law of the land. But if you can't discriminate on the basis of race, can you discriminate on the basis of LGBTQ status? And if you can discriminate on the basis of LGBTQ status because that status violates your religious views, can you discriminate on the basis of race? Are we going back to pre-1964? Not an easy one for the Supreme Court to resolve. However, if you want to get back to basics, we have a state statute, the Colorado Anti-Discrimination Statute, and an amendment to the Constitution, which is higher. The Constitution is higher. Why is it higher? Because the Constitution is the supreme law of the land, and the First Amendment is a part of the Constitution. That's the hook on which I predict the Supreme Court will hang its hat by saying the freedom of speech and the right to remain silent and the prohibition against interfering with religious views trump, lowercase t, the Colorado anti-discrimination statute. Does it trump it just for LGBTQ status, or does it trump it for other things as well? We'll see what my buddy Neil Gorsuch does on this one. I suspect he'll be the swing vote. I mean, no disrespect. It's Justice Gorsuch. It's just I have such a high regard for the purity and the honesty of his intellect. Judge Napolitano for Judging Freedom.